Thank you. So from the standpoint of a former agency general counsel and also a practicing lawyer, because I head up the environmental department at Covington and Burling as well as teaching full-time at Yale Law School, the biggest uncertainty that agencies face, or one of the biggest uncertainties, is judicial review. Empirical work that Peter Schuck and I did in the late 80s and is published in the Duke Law Journal in 1991 shows that about 40% of the time in rulemaking, some portion of an agency rule is going to be found invalid in court. But the agency doesn't know which rules and which portions of rules will be found invalid. And that led my colleague, Chaz Tyler, and I to think about the problem that we call agency severability clauses. Congress often says in a statute, if some portion of this is set aside, the balance will remain in effect. And one of the anomalies we found when we looked into it is that agencies don't do this very often, and when they do, courts don't typically respect it. So the main paper is a forthcoming article. It's a co-authored article that will appear shortly in the Yale Law Journal about agency severability clauses. And Chaz is going to take the lead on that, which is really the main paper. But Jennifer, trying to get 2 for 1, asked me if I would also do a little something on other techniques that agencies use to manage uncertainty. So I put together a second paper about that I'll briefly summarize. And basically, this does not purport to be a comprehensive list. These are just the ones that I could think of. So I'm very open to people thinking of others and bringing them to my attention. But it basically breaks down into 2 categories: techniques to reduce uncertainty, to minimize the number of errors that the agency thinks it's going to make, and then techniques to reduce the consequences of errors that cannot be avoided. I'll go through the techniques to reduce errors quickly because an awful lot of them are obvious. Although it's interesting that I think one of the things that differentiates the US system from many of the systems abroad is how much attention we put into these various techniques to try to reduce uncertainty in advance. The one that I think is perhaps, and another way to look at it is that many of the familiar features of administrative law can be understood in a new frame when you think about them as techniques for reducing or managing uncertainty. So I think that's a productive way to think about some of the things that we do and we take for granted. The most interesting to me in the techniques to reduce uncertainty is point number 1, timing regulation to anticipate future shocks, future updating shocks. And this is something that grew out of my experience at EPA in the late 80s, early 90s. I discovered that the agency views itself as having a large number of potential risk reduction investment opportunities. So the decision of whether or not to work on one thing or work on something else, there doesn't seem to be much of a perceived cost because we're constrained by the amount of staff and time we have available. So as a result, we would often decide to not regulate something now because we anticipated that at some relatively near point in the future, we'd know more about the problem, either because we'd know more about the dose response curve or because there was a new technology that was coming out. I think this is interesting because what it highlights for me is sometimes you think you can predict what changes are going to be in terms of your knowledge, but not necessarily predict what their content is going to be. The more interesting, I think, part of the first paper has to do with the second issue, which are the techniques to reduce the consequences of error. And probably the most common and significant of those are decisions to bias the direction of error, to make a decision that it's better to err on one side than another. This is basically the concept of precaution. And it's very, very common at EPA and other agencies to decide that we're going to make a conservative assessment because we know there are going to be errors, but we think it's better to err on one side than another. A second technique, which a number of people have commented upon, is basically periodic or retrospective review that promotes Bayesian learning. If you know that you're going to be wrong, you may want to come back every 5 years and re-examine the situation. I give a number of examples of that, many of which are statutory. The third, and perhaps I think the most significant technique, is what I call resilience. And this has been rather elaborately explored in an underappreciated book by the late political scientist Aaron Wadowski, who talks about designing decisions so that you can recover from mistakes more easily. And you limit the consequences of an erroneous decision. And I give a number of examples of that from EPA experience, but one of them in an area of toxic chemical control that Wendy and I work in is EPA has a standard consent decree. When not very much is known about a new chemical, it will typically, through the standard consent decree, approve the chemical, but limit the production amount, say it can only be used in certain uses, can only be exposed to workers with informed consent. Similarly, FDA has similar processes, and these are ways to essentially limit the damage from an erroneous decision. Economic incentive systems, very, very common, the Coasian notion of contracting around inefficient decisions or incorrect decisions by government. One of the advantages of those softer systems. An interesting application of that I talk about in the paper are variable user fees that essentially allow the agency's customers to decide what are the most important priorities for the agency to work on in terms of approvals by allowing companies to pay more for a swifter turnaround time. Another very important technique, which is pervasive in American law, is the concept of redundancy. And this runs throughout our law and our constitutional system. It was identified at the turn of the previous century by Walter Bagehot, the first editor of The Economist, who basically says it's pervasive in the American system that rather than trying to have a single authority and make it good, we have multiple authorities in the hope that their multitude will atone for their inferiority. And actually it's a very, very common technique, and I give a number of examples of it in the paper, but we take it for granted. But this is one of the reasons we build our regulatory systems on top of common law remedies. We have a political culture which believes that there are no perfect institutions, but that you can account for the imperfection in institutions by throwing multiple approaches at the problem. And the last system that we identify, of which I see agency severability clauses as being a particular case, are what we call standby regulatory systems. So agencies faced with uncertainty, it says if certain things happen in the future, some other remedy will go into effect. You don't know whether the future event's going to happen or not. Good example are the non-attainment provisions of the Clean Air Act, which say EPA approves a state implementation plan by predicting that it's going to achieve compliance with the National Ambient Air Quality Standards. But if it doesn't, there are measures that automatically go into effect. And with that, let me turn it over to my colleague Chaz, who will talk about agency severability clauses.
So thanks, Don, and thanks everybody. It's been a really great conference so far, and I've really enjoyed the conversation. So as Don mentions, the paper's about administrative severability clauses, which are really the agency's attempt to specify what the court should do in a particular remedial situation, namely after the court invalidates a particular provision of a regulatory rule, should it leave the remainder of the rule in effect. And so the most perspicuous example of this that I think you'll find if you search for these phenomena is this Clean Power Plan, the recently proposed rule by EPA that's set to be finalized over the summer. So what the rule provides are 4 basic building blocks that the agency believes, if the states implement, would achieve the best system of emissions reductions. They think coal plants to be used more efficiently. Our energy production could rely more heavily on gas plants. The states could rely more heavily on renewables and nuclear power. And the states could try to improve the efficiency with which end users use their electricity. And then right after the building blocks, you'll see in the regulation, they include a severability clause. And it says, if a court finds any of the first 4 unlawful, you should assume that the best system of emissions reductions is what would result from the remaining 3 or 2 or 1 in the plan. And I mean, EPA takes this particular provision really seriously. One evidence of that is that after Don and I published this blog post on ACUS's website, I actually got calls from several staff members on the House Energy Committee asking me if I could share anything that I had found about severability clauses, which is, I think probably a typical thing that happens in the lives of many of you, but it's not very common for me. So we think this is the thing to notice about severability in this context is in the absence of guidance from the agency, the court is going to be asked, well, does the rule, absent the invalid provision, do what the agency wanted to do when it promulgated the original rule? And that's the sort of question, namely the question whether the rule continues to function sensibly or work as the agency wanted it to work, is the sort of question that's going to involve all the same considerations that went into the agency's original promulgation of the rule. In other words, it's not the sort of question that a court is typically able to answer. There is, in other words, a lot of uncertainty with respect to the court's information or knowledge about how to answer that question. And so what the paper tries to do is favor a particular allocation of decision-making authority that gives that decision to the agency. We tried to find these devices in all of the major rulemakings that have been promulgated since 2000. We found the FTC actually uses it fairly frequently. You have to realize that not every rule is going to be amenable to severability clauses. So the FTC's usage of it suggests that they actually think there's some benefits to it. But these are just a few selected percentages of rules. In the other agencies, every other agency uses it less than 1%, if ever. And then
Where was EPA now?
EPA is not on that list there. I think EPA's used it a handful of times, but relative to the number of rules that they promulgate, it's a fairly low percentage. It's in the appendix to the paper if you want to look at that. And then this is the approach that courts typically take to severability clauses, which is that it's sort of like, there's a famous quote in the paper that says it's sort of like wearing clothes. You don't notice them when they're there, but then when they're not there, they do. And so the courts, the typical analysis of severability clauses is just to say that they're there, but then to do the underlying severability analysis as if the agency hadn't made any comment about it in the first place. So just to tie the theses of the paper back to the topic of the conference, as Don mentioned, I think there's 2 ways in which uncertainty could potentially be involved. And you can think about this by separating 2 questions out. The first question is a court going to strike down a particular substantive provision? Agencies and regulated entities are going to want to know the answer to that question when they're trying to decide how best to regulate or how best to adjust to comply most efficiently with the new rulemaking. And if they're facing the uncertainty that a court will later invalidate a particularly suspect provision and maybe also the entire rule, then there's going to be some risk involved that the severability clauses could help to reduce. The other thing is the question that I mentioned earlier, which is the sort of fundamental question of the severability analysis is, does the rule do the things that the agency wanted it to do in the absence of the provision? And here, the way I see it being relevant is that with respect to that question, courts are really in a situation of deep uncertainty. They really just don't know, with respect to a lot of regulations, how that kind of question could be answered. And they can't cost effectively obtain that information, let alone do the type of investigation that the agencies can do. So severability clause is a way of shifting from one actor who's likely to be in a position of relatively deep uncertainty to an actor who's going to have much better sense of the probability distributions, the outcomes, and those sorts of things. So thank you very much.
Thank you. So I'm not going to talk about administrative severability clauses. It's way outside of my expertise. Looking at the paper, though, did give me a hint on what I wanted to focus on. It's because as I read the Yale Law Journal paper, and I occasionally do read law journal papers, often struck at how different the language is from economics papers. And then when I read the paper you made up directly for this conference, then there were a lot more things that I could recognize, but still the language is different. It's all words. And so
that was intentional with deference to Judge Posner.
Yeah, some of them were more than a single syllable, though. So I decided, I mean, recognizing that this is the very end of the conference, I thought this, with a mix of people with different cultural backgrounds in the room, that I might anyway, no matter what was in your papers, want to talk about this issue of the two traditions of qualitative and quantitative assessment of uncertainty. So that's what I'm going to do. I will draw a bit on what Don wrote. So start off, legal analysis of regulation is largely verbal or qualitative. Economic analysis is largely mathematical, quantitative. And the two papers they exemplify the legal tradition. In the first paper that Don Elliott talked about, there were all kinds of words he used that I was trying to think, well, I can translate these into terms, jargon that we use, and say, here's some of them. So timing regulation to anticipated literature development, that sounded to me like an optimal stopping problem. You hold off until you feel like this is the right time to make a decision. So I say, oh, optimal stopping, I know what that means. Precautionary principle, of course, is the maximum decision criterion in terms of formal analysis of decisions under ambiguity. The only thing I would say is a side point. I'm sure you're right that the EPA really does give much more weight to errors of one kind than the other. As an outsider, I often find myself wondering why that's the case. And I think Adrian yesterday talked a bit about this, about why is there this, do we defer to pessimism much more than optimism? I think that really bears some thought. I mean, I think there are bureaucratic reasons why that's done. In terms of the incentives that people in the agencies face. And I'm not sure from a social welfare perspective that we should be giving much more weight to errors of type 1 than errors of type 2. So I really wish we had much more time to talk about that. Now it's a topic of its own right. I'll just leave it. Adaptive management, recovery ability strategy, it's optimal control of dynamic programming and so on. And then finally, on resilience and redundancy, I could map it into things. I've been doing a lot of work of my own on using diversification as a strategy for dealing with uncertainty in public policy. And everyone understands diversification in financial portfolio allocation. I've been formalizing the same idea for public policy. And I think I can map some of these notions of resilience and redundancy into what I call adaptive diversification in my own work. So I'll just mention that. Now, I put this in bold. I write, verbal discussion can be useful to introduce concepts, but it usually does not yield criteria for decision making. And to make the point, this is a long quote from Don Elliott's paper, which is a quote from something he wrote earlier with Brendan Elliott. So the first paragraph is introductory. I want to focus on the second and the third paragraph. It's about predicting things. Because these quantities are incommensurable, and because they involve predictions about the future, they cannot be reduced to a precise formula. And I say, wait. This is what we do all the time. Just because things are different and because they involve prediction in the future, that doesn't mean that we can't reduce them. We do. I mean, this is what we have predictive probability distributions for to formalize that's a precise formula. And when we don't have predictive probability distributions, we may have bounds, which is what comes up in the whole literature on ambiguity. So in my world, we do that all the time. But then the last paragraph I found interesting, that it may be helpful to frame these issues nonetheless, because there are many easy cases in which it's so obvious, he writes, that the harm that may occur in the meantime is far greater than any likely benefit that may result for waiting more information or vice versa, so that the verbal kind of analysis and not quantifying things still suffices for making a decision. And that's true in some circumstances. However, it leaves open the case about what do you do in the difficult cases, when it's not so glaring in the face that one way of doing things is better than the other. And I think that's where the quantification of the economic analysis comes in, is that we want to attack the difficult cases, and to do that we do try to quantify the uncertainty, and the two tools we use that are either as predictive probability distributions or as bounds, and then depending on how we've quantified the uncertainty, then we apply formal decision criteria. So when we quantify the uncertainty as a predictive probability distribution, then the standard is to use maximization of expected utility. And then when we feel that we can't do that, and there's been some different views about this at the conference, is that when we don't feel that we could put a probability distribution on, then what can we do? And then we have this whole literature on decision making under ambiguity. My own work is focused on this minimax regret criteria. There's no point in discussing that now. Maximin we've already discussed as the precautionary principle. Adrian yesterday talked about alpha minimax regret, which is a whole class of procedures. And they're different procedures. They give different answers. It matters. But the quantification really matters because it shows how the decision criteria does affect decision making. Okay? So that's the thing. Those are what we do. Now let me give two illustrations. Mandatory vaccination. It's been curious to me. I have a lot of interest in health policy under uncertainty, and that's where much of my work has been focusing. Those have not been the regulatory issues that have come up in the past day and a half, but they're very interesting one. So mandatory vaccination very recently has been a subject of considerable controversy, centered on this tension between personal freedom and public health. And so, if you mandate vaccination, you will increase public health by having a higher vaccination rate, lower disease transmission. But on the other hand, you're going to force some people to get vaccinated who don't want to get vaccinated. There's partially just the ordinary cost of vaccinating people. But then the big issue has been the personal freedom, religious exemptions, and all the rest of that go with that. It's part of the social cost of vaccination. So I do some reading in the medical, public health, and a bit in the legal literature as well on mandatory vaccination. And it's very clear, these are all articles that are written verbally. And it's very clear there's a considerable understanding of the conflicting public objectives. If you have mandatory vaccination, there'll be a benefit in public health, but there'll be a diminishment in personal freedom and so on. But what these articles don't do is they don't address how society might reconcile the conflicting objectives. You can just say that there's a trade-off. Mandatory vaccination has an advantage and a disadvantage, but if you keep things verbal and qualitative, you can't go much beyond that. So here's where the economic quantification tradition comes in, because we have a long-standing practice, it goes back to the early 1800s and Jeremy Bentham and so on, of explicitly writing down a social welfare function or a social cost function, I think is more natural to think of in the vaccination case, and considering a planner who wants to optimize this function, and that's the way we do it. And of course, all of cost-benefit analysis fits within this framework. Cost-benefit analysis is just a operationalization of this idea of a planner who optimizes social welfare. That's what it is. So in the case of mandatory vaccination, you do have to make a plus. I think a great plus of all this is making very explicit what the social welfare function is. Now, people may argue, well, is this the right social welfare function that I want to use or a different one? But if you make it explicit, you can have an interesting discussion of that. Okay? So presumably, this is still qualitative, you want to minimize the social cost of illness and vaccination. And mandatory vaccination has this advantage and disadvantage. But that's as far as you can go verbally. to actually make a decision on whether in a particular context you would want to mandate vaccination. This, by the way, in the United States is a state level decision rather than a federal level decision. That's just the way it's worked in our system. Is you have to specify a specific social cost function, and that quantifies the advantages and disadvantages of a mandate. That yields a well-defined optimization problem that you can write down, and anyone who knows the simple math can just look at and say exactly this is what we're trying to optimize. And so there's a literature on that. So there's a literature that dates back at least 30 years where economists and epidemiologists have studied choice of vaccination policy as a social planning problem. And I write here a deterministic problem, because the presumption in the literature has been that the social planner knows the outcomes that alternative policies would yield. Now this is where my own work comes in, and I'll just say a word about this, is that I'm concerned with vaccination policy under uncertainty. The particular uncertainty that's been of interest to me is in predicting what in the epidemiology literature is called the herd immunity or the community immunity effect or the indirect effects of vaccination. This is a key problem in studying vaccination policy, is that if I increase the vaccination rate, it lowers the probability that other people get sick. But if you ask how much do we know about that, about the magnitude of this herd immunity effect, when you dig into the literature and the models, which is very similar to like in the integrated carbon assessment models too, these are hard problems. And I decide we don't really know all that much, so I formally have studied this. And I have a working paper on my webpage on choice between mandatory and decentralized vaccination as a problem of regulatory policy under uncertainty or ambiguity. Okay, so I'll just mention that as a kind of illustration of how I would see going about this. So obviously don't have the time to talk about it. Now, the remaining time that I have, I want to focus on something that drives me crazy, which is the Food and Drug Administration. I've learned that Artie, who's been sitting next to me, that we share that the FDA drug approval process drives us both crazy, and I think she's going to have some things to say about that as well. Cool. So everyone knows, I think, in general terms, that what happens with FDA drug approval is their randomized clinical trials are run, and then the decision is made, up or down decision on whether to approve or not approve a drug. Now, there was a 2012 amendment to the Food, Drug, and Cosmetic Act. It first astounded me that there was any law passed at all by Congress in 2012. I thought Congress had passed no legislation in 2012. It was about the depths of the dysfunction in Congress, but apparently this was passed. And one piece of this amendment to the act is the basic act under which the FDA operates, called on the FDA to institute what Congress called a structured risk-benefit assessment framework. And so here's a quote, section 505 block, is amended by adding at the end the following: the Secretary shall implement a structured risk-benefit assessment framework in the new drug approval process to facilitate the balanced consideration of benefits and risks, a consistent and systematic approach to the discussion of regulatory decision-making and the communication of benefits and risks of new drugs. So Congress is telling the FDA to do a better job of structuring, formalizing, and communicating what's going on in new drug approval. Now, when I look at this, the congressional language, statutory language, suggests to me a quantification of risks and benefits, weighing the two and doing cost-benefit analysis of some kind. But the FDA, in response to the amendment, put out a public document from which I'm going to quote at some length, because it really bothers me, in which the FDA explicitly rejects the use of formal decision analysis in drug approval. Okay, so here is it's a long quote from the FDA, what the FDA wrote, and then it'll be almost done. Read along with me. In the past, some FDA stakeholders have indicated there's room for improvement in the clarity and transparency of FDA benefit risk assessment, and so on. And the second paragraph, some have argued that drug regulatory decisions should be based on more formalized and quantitative approaches to benefit risk assessment, including the assignment of weights to benefit and risk considerations. That's what I want to focus on, because the FDA drug approval process will consider the effectiveness of a drug here, and will consider the side effects of the drug over here. Those are the benefits and the risks. Any economist would think, well, if a drug has some benefits and effectiveness and some side effects that it may make some people sicker, that in order to make a coherent decision, you have to put some weights on the effectiveness of the drug and the side effects. And the FDA strenuously objects to this. This is FDA language. It says some people want to put weights. Others, however, are skeptical of fully quantitative approaches and consider such attempts to be a highly subjective exercise that would add little clarity to regulatory decision making. Okay, that's what the FDA states in this public document. And then it goes on and it says about definition of what quantitative benefit risk assessment means. It basically says putting the weights on again. And it goes on and on about putting weights and putting weights. But then it says towards the bottom, the subjective judgments and assessments and assumptions that would inevitably be embodied in such quantitative decision making would be much less transparent, if not obscured, to those who wish to understand a regulator's thinking. I am not a lawyer, I am not a regulator, I have no sense at all of what this paragraph means. It says that quantifying things will obscure regulators' thinking. Finally, it says that the FDA is, I'm almost out of time, has dropped. It says it's going to do this, and it's going to do something that they call a structured qualitative approach. You can read what the FDA says about this. I don't understand what the structured qualitative approach means. In the end, I think that whatever the structured qualitative approach is it's not transparent. What the FDA says it's transparent, it's not. The FDA provides to the public after a drug approval decision only what it calls a summary of basis for approval, which kind of summarizes what went on in the committee decision. When a drug is rejected, the FDA makes public no documents at all, which I find very interesting. I learned in Europe that's not the case. In Europe, when they reject, there's a public document as well. The FDA makes something public only when there's approval. I think what's going on with the qualitative drug process of the FDA is it's a bureaucratic process. It shields the FDA from outside scrutiny. That's my own conclusion from this. And I think they should be doing quantitative analysis. Now, the open question, and I'll just leaving aside the FDA and going back to the basic questions, we have these different cultures. I mean, the whole purpose of a conference like this is to bring people together from the different cultures. We really do need to bridge this. I don't know if it's just a gap or a chasm between the quantitative and qualitative assessment of cost and benefits uncertainty. I've made my own small attempt in this 2013 book, which is actually written in English, not in math, to the best of my ability. And but I think we need many more conversations like this. Thank you.
I'm the last speaker on the last panel on the last day. So I'm going to try to be energetic and keep you awake. I'm going to come at this question from a somewhat different perspective than that of many in the room. I'm sort of an outsider to this risk world. I am an innovation person, and so I think about these issues from the standpoint of uncertainty, in particular from the standpoint of uncertainty associated with predicting innovation. I think, though, that still has, I still have a lot to say, or something to say, about uncertainty in other realms as well, not least because I think that a lot of the models for doing cost-benefit analysis of risk don't sufficiently take into account induced innovation or endogenous innovation. So it was interesting to me that, as I understood it anyway, the social cost of carbon analysis assumed a certain amount of, assumed a declining cost of clean energy, but that was exogenous, as I understood it. Well, I think we need to endogenize those things, because innovation is endogenous, and we need to endogenize uncertainty in order to get our models right. And I've spent a fair amount of time, I was at the Patent and Trademark Office as the chief policy person, worked a lot with OSTP in particular, thinking, and continue actually to work with them, with a fellow named Dan Correa, to think about how we could begin to think about endogenizing innovation into these models. Circular A4 doesn't say anything really about that, and thus far we haven't gotten OIRA to be particularly interested in this question, maybe because it's just so darn hard to endogenize innovation. And I can see that. I mean, so what Circular A4 says is, well, use performance standards because that's more market-based. We can stimulate innovation that way. That's all good. And Al, who stepped out of the room, has shown through some of his retrospective case studies that market-based approaches, performance standards, and the like seem to do a better job than other approaches, as we might expect, because the ex-ante expected costs of the regulation are highly overestimate the actual costs because markets adapt and they innovate, and we come up with much cheaper ways of doing meeting the standards than was originally anticipated. So he has some nice retrospective case studies, but as he points out in his papers, and others have pointed out, these are just case studies, they're not necessarily representative. I think Dick Morgenstern has been on some of those papers as well. So we don't have good models on how to endogenize innovation, and so that's an issue, but I do think that we should all think about this more. The other piece of knowledge that I think I bring to bear is that innovation, of course, and technological innovation in particular, or scientific advancement, can reduce uncertainty. So a lot of uncertainty arises because we don't know enough about the science, and there are ways to think about policy levers we can think about how to do that sort of scientific advancement better or worse, and that's what I spent a huge amount of time thinking about. So I'm hoping that part of my commentary will also be able to, will draw upon that, and I think hopefully will have some insights into the basic Elliott-Tyler analysis as a consequence. So the basic Elliott-Tyler analysis is, as they've reported, first, they want to look at techniques intended to minimize errors, and second, techniques intended to reduce the cost of errors that occur. And then in the latter category, they include severability clauses. I do teach administrative law, so I'll talk a little bit about the severability clauses as well. All right. So I think one of the most interesting, and I think, Don, you said this as well, that you thought this was the case as well. One of the most interesting pieces of the minimizing errors approach is the timing question. And as you note in your paper, sometimes you waited when you were at the EPA till the science had settled down. Of course, that has drawbacks because while you wait for the science to settle down, lots of bad things can happen. So how about proactively inducing the science to settle down? You talk about agency-sponsored research. Well, that's great. There are drawbacks to agency-sponsored research. Agencies have limited information. They may have limited information as to who to fund. There's a lot of literature these days on the wisdom of crowdsourcing and the like. The patent system, which I do spend some time focusing on, is one way of decentralizing or drawing upon decentralized knowledge. So, unfortunately, if we want to advance the science as an agency, we don't necessarily want to rely on the patent system because patents are filed by people who want to advance whatever science they want to advance and not necessarily the science the agency wants to advance. So another approach that we spent a fair amount of time on when I was in the administration was prizes, and the X Prize is the most famous of these prizes currently, but prizes have a long history in the U.S. and other systems of innovation. So, for example, Charles Lindbergh was motivated to cross the Atlantic by a prize. More recently, the X Prize has promoted innovation in space travel and has been quite successful in doing so. www.challenges.gov actually has a whole range of prize offerings that government agencies are making on various scientific challenges that they need to solve. As far as I can tell, most of these challenges do not involve advancing science so that we can do better regulation, but it seems to me that's a place where we could have some prize systems in place. So that's making the science better ex ante. What about ex post? Well, ex post, we've talked a fair amount already about retrospective review and adaptive management and Bayesian learning. One piece of the puzzle that I think has not been adequately elucidated in our conversations thus far is that there's a benefit of systematic learning that can be achieved through this retrospective review. So not simply just tweaking that individual regulation, whatever it may be, but rather tweaking the whole system or learning about how to tweak the whole system better. So as some of these retrospective studies have pointed out, market-based approaches work better than other approaches for purposes of inducing innovation. Those are the studies I was referring to that Al and others have done. There are also some interesting retrospective studies that suggest the market structure of the industry can affect compliance costs. So these are some benefits of systematic learning that can be achieved through retrospective review. Of course, the challenges are significant as well. We might have more data, but ex post rather than ex ante, but only if there's systems built in for data collection, which there often aren't. And ideally, we might be able to even have some natural experiments we can find as a consequence, or quasi-natural experiments we can find as a consequence of ex post, or in doing ex post review. But oftentimes, at least the current, it seems like currently, and again, Al's work shows this, often the data is missing, even ex post. There's also the issue of selection of rules on which to do retrospective review. I too will join in the criticism of the precautionary principle and maximin as a default principle. I think the FDA does operate to a significant extent on that principle. I'm not sure it's I think it seems to me a minimizing errors principle rather than a reducing cost of errors principle. It's just a small semantic point with respect to Don's paper. With the FDA in particular, of course, this maximin principle is sort of peculiar because FDA deals with risk versus risk situations. There are risks on both sides. If you don't approve a drug, there are people who will die. If you do approve a drug, there could be people who die. So there are large health and safety costs on both sides, and I think that the FDA's approach of largely of a maximin principle is not necessarily a good one. And it's interesting to me that in Europe, where we think the precautionary principle holds more weight, in point of fact, they've taken a non-precautionary approach to drug approval. So this is a slide from Hans-Georg Eichler of the EMA. And if you look at how he describes the regulator's dilemma, this is a play on the innovator's dilemma framework by Clay Christensen. If you look at how he describes it, the blue bars, risks on both sides, patient groups demanding early access to drugs because otherwise people will die. And on the other side, people might die if drugs are approved too quickly. The red bar, by the way, has to do with one of the pieces that Don was talking about, which is when do you decide? The EMA has decided to do a very different approach than the precautionary principle, as I mentioned. They've set up 10 cases in which they will approve drugs very early and then monitor post-approval. So that's a form of adaptive management that we have yet to utilize in this country at the US FDA, I think because of bureaucratic considerations for the most part, which we can talk about. Last but not least, I want to talk about how we might maximize use of existing data. So big data to knowledge is a mantra that some people have adopted, including some research funding agencies. So we have lots of data out there. It could even be considered big data, but to make it knowledge, you have to deal with the problem of data silos and legal barriers to aggregating data. There's also the problem of debiasing data, because if the data comes from the private sector entirely, it may have been generated for with certain biases that have to be accounted for. So I want to just mention briefly 2 FDA case studies that I think show us some of the challenges of using existing data and maximizing its use so as to generate the information that we need to regulate better under conditions of uncertainty. These are off-label use. There's a lot of off-label use that goes on in this country, and basically, for reasons of time, I can't go into it in great detail, but we don't know in a lot of these cases whether the benefits of this off-label use exceed the risks, and there are many legal barriers to impede this aggregation of information, and the FDA certainly is not doing anything because of, I think in part because of bureaucratic incentives to try to circumvent or overcome these legal barriers. When the FDA does approve drugs, which it often does too slowly, it doesn't do much to make sure that ultimately the data on which it has approved the drugs is reviewed fully by outsiders as well, because it does make mistakes, and it hasn't done anything to make that data on which it approves drugs public. I was part of an IOM committee that tried to urge them to do so, and with little success as it happened. So there's that issue as well, that even when the government has the relevant data, it doesn't necessarily maximize its use. In fact, it does everything it can oftentimes to keep it secret. So just a word on some severability clauses. Here I think that I agree almost entirely with what has been said. I think judicial review can be stochastic and destructive, in the words of Jerry Mishaw, quoted in the paper, and I think Chevron-style deference to agency severability clauses is a good idea. A couple of nitpicky legal questions that you might consider, although I think the paper has been published already. So I wasn't sure as to why your step one de novo review on the remainder, the stuff that remained after the severability had, the severable portion had been taken out, would be arbitrary and capricious. It strikes me, and this goes back to some of what Adrian was saying yesterday, that if you let the DC Circuit get away with arbitrary and capricious review, they're going to get away with a lot, as suggested by a case you cite in the paper, Judge Doug Ginsburg's opinion in the Broadcasters Association case. So I think that's a real concern from my standpoint with regard to your framework. And then question two, even with Chevron, would agencies actually use these severability clauses? I think they create a target on one's back, and that consideration is probably, in my view, probably a dominant one. So thank you for the opportunity to comment.